Hi, myself Dr. M. Saranya, Assistant Professor of BBA Department. Now I am going to present a topic on conditions and warranties in Sales of Goods Act. The Sales of Goods Act define and enlist the law relating to the sale of goods. A contract of sale of goods is a contract in which the seller sells or transfer the goods to the buyer at a stipulated price. To constitute a contract of sale, it is important that there are two parties who enter into the contract with their free consent. There is full disclosure of the goods, and the goods are transferred from the ownership of one party to another at a specific price. In a contract of sales of goods, parties stipulate in relation to the course of trade or sales. Such stipulations are the basis on which the party decided to enter into a contract or not, and they may either be in the form of a conditions or warranty. Condition is perceived as a preconditions in which the basics of a contract, and warranty is like a security or guarantee which is available if the goods purchased are damaged or contain any fault in them. Section 11 to 17 under the Sales of Goods Act talk about the conditions and warranties and their role in the formation of a contract. Next, we are going to see about the conditions at state in Section 12 of the Sales of Goods Act. Condition is an essential part of the contract or the main subject matter of the contract on the basis of which a contract is entered into. It is on the seller to fulfill the conditions of a contract. If the same remain unfulfilled, then the contract can be terminated or repudiated by the buyers, and they can also claim damages. For instance, A wants to buy a smartwatch which remains charges for an average of 15 days minimum. B suggested a watch to A as per his condition. However, its charging remains only for 5 days. Here, A can return the watch to B and claim damages for the non-fulfillment of the conditions mentioned at the time of contract. Next, we are going to see about types of conditions. First one is express condition. These include the conditions which the parties to a contract mentioned to be the included or be fulfilled as a part of the contract. It is done either orally or through written means. For instance, A tells B that he want to buy a car with an average of 20 km per hour. So here A expressly state his condition on the basis of which he will buy a car. Next one is implied condition. In a contract of sale, there are certain conditions which are automatically applicable or incorporated in the contract. There are various implied conditions which are incorporated in different contract of sale. They are as follow. The first one is title. As per the section 14a, the implied conditions on the part of the seller is that in a contract of sale, he has a right to sell the goods or transfer the ownership of goods, and in case of an agreement to sell, he has the right to sell the goods at the specific future date when the contract is to be performed. For instance, A sells a laptop to B, but he does not have the right or title to sell the same. In such case, B would be liable to claim compensation from A and recover the money that he paid for the purchasing of a laptop. Next, we are going to see about the types of warranty. First one is express warranty. These include such warranties which are derived by the parties at the time of a formation of the contract. They may be agreed to either orally or through written means. Next one is implied warranty. Implied means things which are included automatically. Implied warranty resembles to an assumption. So therefore, implied warranties are such which the parties have not expressly declared but are assumed by them. There are various types of implied warranty such as possession. Section 14b states that there is an implied warranty that the buyer is entitled to enjoy a peaceful possession of the goods part. For instance, A stole B's watch and then sold it to C. C in good faith bought the watch and is thereby entitled to its peaceful possession if B should C and claim back the watch, then C can claim damages from the A under the implied warranty of a peaceful possession. In Mansion versus Birmingham, the plaintiff bought a typewriter from the defendant who was not the true owner of the same, and also spent an additional cost for its repair and maintenance. However, the plaintiff had to return the same to the true owner. The court stated that the defendant had breached the contract by not allowing the plaintiff to enjoy its peaceful possession, and therefore was liable to compensate the plaintiff. Thank you.